Here's the deal. If and only if you find all the evidence to back this up, I'll do it. I'll take it on.
Doing the right thing, Mr. Masry.
Yeah. Remind me of that when I'm filing for bankruptcy.
First, there was the Oscar-winning legal drama, Erin Brockovich, that catapulted the already successful lawyer Thomas Girardi into the national limelight. That was back in 2000. Then in 2015,
this season on The Real Housewives of Beverly Hills,
there was his wife, Erica Jane, becoming one of the Real Housewives of Beverly Hills, with her ostentatious displays of wealth, even for a real housewife. Now that lavish lifestyle, including the mansion in Pasadena, 2 private jets, luxury cars, extravagant jewelry, and exclusive golf clubs, is part of the prosecution's case against the 85-year-old Girardi. He's charged with 4 counts of wire fraud for allegedly stealing $15 million in settlement funds that were supposed to go to his clients to support that extravagant lifestyle. Girardi's lawyers blame the law firm's CFO, saying he stole millions of dollars in the course of a decade. Joining me is former federal prosecutor Agustin Orozco, a partner at Crowell Moring. What was Thomas Girardi's reputation before this all came out?
Yeah, Tom Girardi was a big name in the Los Angeles legal market. I went to Loyola Law School, and there were buildings named after him. You often saw his law firm sponsoring a number of events. You usually saw him at a number of networking events around Los Angeles. Everyone knew who he was. Obviously, his reputation precedes him with the Erin Brockovich movie. And so, it's hard to be an attorney in Los Angeles and not know who Thomas Girardi was.
When did these allegations of unethical conduct start to come out?
I think a lot of it started with the Chicago case that came out a couple of years ago. I think the Chicago indictment was the first time people really started hearing about the misdeeds of Girardi and his law firm, and things trickled down from there. You had the state bar allegations, and then you had the indictment out of the Central District of California. But if memory serves me correct, it was the Chicago case that really started the public's knowledge of his legal issues.
Yeah, in the Chicago case, he's charged with stealing millions in settlement awards from Boeing to families of a plane crash that killed 189 people. What is he being tried for in Los Angeles?
Tom Girardi is being prosecuted for wire fraud. And what wire fraud is, it's a statute essentially that criminalizes conduct when you defraud a victim, an individual, a company, while using interstate wires. And what it does essentially is it says, did the person being accused of this crime, make a misrepresentation or omission to the victim in order to deprive the victim of money or property? And did they use interstate wires in the process? And the wires really is just a jurisdictional hook. Really, the meat of it is, did you make an intentional misrepresentation in order to steal money from this other person?
And tell me about the allegations that he was using his clients' trust accounts and giving them different stories about why he couldn't get the money to them.
If you look at what the wire fraud statute criminalizes, again, it criminalizes, did you make a misrepresentation or an omission in order to deprive somebody of money or property? If you look at the ethical rules that all lawyers must follow in California, they require you, whenever you have client funds, to put them in a client trust account, and the money stays in that client trust account until it's appropriately been divided to your client and to any other experts or agents that you've retained throughout the case. And if you look at this Girardi case, what they're saying is that Girardi took the money from settlements that belonged to his client, and instead of following these ethical rules about storing the money in the client trust account and appropriately dividing the money up amongst those who needed the money, notably his clients, before taking his percentage of those settlements, instead what he was doing is almost essentially running a Ponzi scheme where he was taking the client settlement funds, using the funds for his own personal expenses, and then when clients were finding out, he was intentionally lying to them about why they weren't receiving their settlement funds and then using the settlement funds from other clients in order to pay off those clients that were already catching on to the fact that he might have been misrepresenting what was going on in their cases and intentionally withholding their money.
So now let's talk about his wife, because during the opening statements, the prosecutor alleged that he used some of the money to support the entertainment career of his wife, used more than $25 million to pay the expenses of her entertainment company. Of course, her lawyer denies all that. Why isn't she being called as a witness, do you think?
They haven't said why she's not being called as a witness. There could be a number of factors involved. First is the marital privilege applies, and so she's allowed to say that statements made by Girardi to her over the course of their marriage is privileged and protected under the marital privilege doctrine. In addition, she potentially has some exposure here as well, and so she has the right under the Fifth Amendment to remain silent and not make statements that could potentially incriminate her. So my instincts are that she's refraining from giving statements and claiming both Fifth Amendment and marital privilege as protections for those statements.
The defense, he's been in cognitive decline, and he's actually been diagnosed with dementia and lives in a memory care facility. Why is he even on trial if that's the case?
The defense made a motion months ago asking, the court to find Girardi not competent to stand trial. And the question for competency is, can you assist your lawyers in your defense at the time of the trial? And medical experts weighed in on both sides, and the judge ultimately held that Girardi is competent to stand trial. Now, the issues of his competency are slightly different during trial. The question during trial now is whether at the time Girardi made these misrepresentations or omissions to his clients in order to keep the settlement amounts that were due to them, whether Girardi, was in such a cognitive decline that he couldn't properly form the right mental state or intent to defraud his clients. And so that's now one of the defenses that the defense is raising during trial. But the issue of competency, whether he's competent to stand trial, is an issue that can be raised again, even after the court already finds that he's competent to stand trial. And to the extent new evidence arises, I wouldn't be surprised if his lawyers raise that motion again during trial.
How does the defense show that he wasn't competent at the time that these incidents happened? He wasn't diagnosed at that point, so how do they go back to show that?
There's a number of ways they can show it. One is through recipient witnesses. If they have witnesses that can testify that at the time these alleged misrepresentations were being made to clients, that in other facets of his life or even in other cases or at the law firm or at home, that Girardi was already showing the inability to remember certain things and was making misstatements or was confused and disoriented throughout that period. They also are going to have a medical expert testify as to his medical condition. And if that medical expert is able to do so, and I assume she will, which is why she's going to testify at trial, she would say that, that his medical condition is one that it would have started years ago and would have been already affecting him at the time that he was making these alleged misrepresentations.
So even if the defense isn't able to prove cognitive decline at the time, do you think that just having that evidence before the jury will make them feel sympathy for him? Why is the prosecution going after this guy, this 85-year-old who has dementia and is being cared for in a facility?
So the prosecutors are looking at the facts and applying those facts to the law. Obviously, what we have here, if you take the indictment at face value and believe all the allegations in the indictment, you have some pretty serious allegations with respect to a notable attorney who was making misrepresentations and flat-out lies to his clients in order to deprive them of money that was due to them. And when you have a situation like this, when you have an attorney, a person that's in a position of trust of his victims, taking advantage of his victims, that's going to be a case that the United States Attorney's Office is going to take very seriously and take a hard look at. And presumably they've looked at the evidence and, they've made those statements now in court, both in court filings and in outside of the presence of the jury and now in the presence of the jury, that, they have evidence to show that at the time these misrepresentations were made, that he wasn't in a cognitive decline. Assuming all that's true, that would be a big reason why they found it important to pursue this claim. Pursue these charges against Girardi. And you have the bigger issue of protecting the public and deterrence. You want to ensure that this conduct, doesn't take place and is not pervasive amongst the legal community, and the U.S. Attorney's Office presumably wants to show that regardless of the situation, that they're going to take these cases seriously.
But do you think jurors might feel sympathy for him because of that, despite the facts?
Yeah, it's one of the reasons why that's a big part of the defense. Of course, jurors are human beings. They're going to be asked to apply facts to law. But it's hard to separate the emotion from the cold, hard facts. And to the extent Girardi looks sympathetic, and there's going to be evidence shown to the jury during trial that shows him as sympathetic in this case because of his cognitive issues, that could work in his favor.
Coming up next on the Bloomberg Law Show, more on the Girardi trial. He's blaming the CFO of the law firm. What effect does it have that the CFO is not being tried with him? I'm June Grasso, and you're listening to Bloomberg. Federal prosecutors introduced Thomas Girardi to a Los Angeles jury as a celebrity attorney turned villain who stole from the clients he promised to champion and said he treated client trust accounts like a personal piggy bank. Girardi's lawyers argued that the real story is not a Hollywood movie, but is more nuanced and complicated by the folding of his law firm, the theft of millions of dollars by his former CFO, and his mental decline. While the jurors saw a diminished Girardi, now 85 years old, bankrupt and disbarred, the prosecution tried to remind them of the celebrity attorney he once was, one they say used his notoriety to steal from clients. I've been talking to former federal prosecutor Agustin Orozco, a partner at Crowell Moring. We've been talking about some possible defenses that Girardi might raise. Another one involves the former CFO of his law firm, Christopher Kamen, who was indicted, but a judge ruled that they'll be tried separately. Is that severance basically a gift to Girardi?
It definitely plays in Girardi's favor because it's harder to point the finger at somebody else when they're sitting at the defense table next to you and making the same arguments throughout trial in terms of being not guilty of the charges in front of them. And so the fact that the CFO is not there, the fact that Girardi's team can make that a focal point of their defense, that this person was the real culpable person here, that he was in charge of running the books and Girardi had deferred to him, all aspects of the financial portion of the law firm, and that Girardi was busy being a lawyer, and on top of the fact that he had this cognitive decline and made Girardi, in addition to his client, a victim of the CFO. It's lined up perfectly for Girardi to put together a defense.
And how much is the prosecution's case, this, celebrity lawyer and the Housewives of Beverly Hills and all that star power and the jets and the luxury lifestyle? How much will the judge let the prosecution introduce evidence of that?
The judge's evidence in as long as it's relevant and the prejudicial nature of the evidence does not outweigh the probative value of that evidence. And so some of that is going to be allowed in. Of course, some of it is extremely relevant. If he was engaging in a lavish lifestyle and engaging in that lavish lifestyle helps rebut the defense that the CFO was the one that was embezzling all the money and not Girardi, that's going to be allowed in. But to the extent it gets to the point where, it's not extremely relevant and it's going to be more prejudicial to the defense, then it would be relevant to the trial, and the court's going to cut that off.
The defense seems to be indicating that it's going to try to make things boring and technical for the jury. The defense lawyer spent something like 10 minutes in his opening statement talking about financial documents and warning the jury about boring details. Can that really work?
You know, when you're a defense attorney in one of these trials, you're already kind of behind the eight ball. You have the United States government putting forth charges. You have the United States government stating that the allegations in those indictments are true. And your job is then to raise a defense and poke holes in the government's investigation. And one of the ways to do that is to dig deep into the documents and to show that there's flaws in the analysis that was done. And so, yes, will that work? It can work. It can work if you can show to the jury that once you dig deep into these documents and you step away from these high-level narratives, that there are serious issues in the investigation that was conducted.
The trial is going to center on 5 former clients involved in personal injury cases. So these will be sympathetic witnesses, no doubt. Will it be difficult for the defense to cross them?
The answer is yes. I think you have to be very careful when you have a sympathetic witness up on the stand, especially a sympathetic victim. And here, as you noted, all 5 of the victims that were chosen to testify have extremely sympathetic stories with serious issues that led them to go to Girardi for help and then misrepresentations to them in order to deprive them of money. And so the defense is going to have to be very careful in cross-examining them because the defense doesn't want to come off as being the bad guys here. Their story is that Girardi is also a victim. You know, they're going to cross-examine the victims to get information out of them as to see whether they actually knew that Girardi was lying to them at the time, and other questions maybe to help them in their defense to prove up their argument about Girardi's cognitive decline. But they're going to be very careful not to come off as bullies or attacking these sympathetic victims.
So does it seem as if the prosecution has a strong case? They've not only got the witnesses, they played a voicemail of Girardi explaining to one of his clients why she wasn't getting the money or he wasn't getting the money right away. And they have emails and letters. They have the clients, the 5 clients, and then there are non-lawyers who work with the firm as well. Does it sound like it's a pretty strong case?
So far, we've only heard testimony from the government's witnesses. But, you know, from everything we've seen so far, it seems like a pretty strong case. You have victims who are claiming, you know, Girardi himself made misrepresentations to them directly about the state of their case, and that these statements by Girardi, you know, when looked at the cold hard facts, were objectively false, right? The question is whether Girardi actually intended to make, you know, a misstatement and lie to his clients at the time, or whether he was confused because of his declining cognitive state. But when you add on top of that the fact that they have attorneys and non-lawyers at the firm who are testifying to Girardi's competency at the time, to also testifying about them being confused and being lied to as to why these victims were not getting the money that they deserved, and that, you know, these former lawyers from the law firm were even quitting their jobs because they were so frustrated with the way things were being mismanaged. All that really adds up to a really strong case, an uphill battle for the defense.
I'm wondering what kind of penalty you think, if he's convicted, what kind of penalty he's facing, considering that he is in this care facility.
You know, the judge is going to, you know, levy a sentence pursuant to the United States sentencing guidelines, and those are really going to be driven by the loss amount that is established at trial. And here, the loss amount is pretty significant. So he's looking at potentially a pretty severe prison sentence in federal prison, but his defense attorneys will raise the cognitive issue at sentencing and will raise the fact that he'll need appropriate accommodations, and the court is going to listen to those and take the steps necessary. Now, the Bureau of Prisons does have medical facilities that can help facilitate that, and there's been other instances where the court has found that, you know, putting the defendant in the care of the Bureau of Prisons, given the advanced age, given health issues, isn't appropriate. And so it's going to be interesting to see how the court weighs those considerations and ultimately rules on the appropriate path forward for Girardi if he is found convicted at trial.
And this is not his only trial. He faces another trial in Illinois.
That's right. He's facing another trial in Illinois based on similar charges with respect to a plane crash case he had from a number of years ago, where the victims are alleging essentially the same thing, that he withheld money that was due to them because of the settlement and lied to them with respect to what was going on in the case. And so the Central District case, he's really, the first domino to fall. And so to the extent he's found convicted in his case, it'd be interesting to see what strategy he employs going forward with respect to his second criminal case in Chicago.
That trial was tentatively scheduled for next year, but it's on hold until the conclusion of this trial in California. That's Agustin Orozco, former federal prosecutor and partner at Crowell Moring. Coming up next on the Bloomberg Law Show, Donald Trump made a lot of promises when he spoke at the Bitcoin 2024 conference, including the promise to create a national Bitcoin stockpile with the cryptocurrency currently held by the U.S. government. Why that promise is alarming to former federal prosecutors. This is Bloomberg.
America will become the world's undisputed Bitcoin mining powerhouse. You'll be a Bitcoin mining powerhouse. You will not have to move your family to China. You will not be moving to China.
Donald Trump made a lot of promises when he spoke at the Bitcoin 2024 conference. He promised to pick crypto-friendly regulators, to form a crypto industry presidential advisory council, to create a stablecoin framework, and call for a scale back in enforcement. But one of his promises in particular has alarmed former federal prosecutors. Trump said he'll create a national Bitcoin stockpile with the cryptocurrency currently held by the U.S. government, because he says the government is violating the cardinal rule of Bitcoin.
Never sell your Bitcoin. And so, as the final part of my plan today, I am announcing that if I am elected, it will be the policy of my administration, United States of America, to keep 100% of all the Bitcoin the U.S. government currently holds or acquires into the future. We'll keep 100%. I hope you do well, please.
That cryptocurrency that the government is holding has been seized in criminal and civil forfeiture cases brought by federal prosecutors and overseen by U.S. judges. Here to explain why former federal prosecutors are finding Trump's suggestion alarming is Bloomberg legal reporter David Voreacos. David, start by telling us about Trump's crypto promises.
Trump made an appearance at the Bitcoin 2024 conference at the end of July, and he promised that he would take all of the Bitcoin that's been seized by the federal government and create a stockpile, and that he will hold it. And presumably this is a way for the federal government to make money. This is a longtime dream of some crypto advocates, that it would put, the full faith and credit of the U.S. government behind Bitcoin, which the government has not been willing to do. Trump did this as he's looking for campaign contributions, and there's a number of people in the crypto world who said that they now support Donald Trump.
How much Bitcoin does the government have?
The government has about $12 billion worth of cryptocurrency, including more than 200,000 Bitcoin.
And so where did all that come from? Is it just from criminal and civil seizures?
It is almost exclusively that, so that in criminal cases, big criminal cases, or cases brought by the SEC or other civil regulators, as part of the case, part of the resolution of cases, the government takes custody of cryptocurrencies.
So this is just like, the government is seizing the Lamborghini, seizing the house, seizing all the cash, let's say. It's the same thing when it's seizing the cryptocurrency.
These are considered the proceeds or instruments of crime. They're either the way that people enrich themselves, as with cash, cars, houses, yachts, planes, or that it's used in executing crimes, primarily money laundering operations. So the government holds that crypto, and they're supposed to, at the appropriate time, sell it. And the proceeds of that sale goes either to victims of crimes to help make them whole or to support law enforcement operations. Now, the triggering point is typically an order by a judge who says essentially that the title is free and clear and no one else has claim to these digital assets.
You talked to several former prosecutors who said this just can't be done. You can't take that money that's set aside by the courts and just take it and put it someplace else.
It's set up under federal statute and regulations that dictate how the assets are supposed to be handled. And it's not really different than other federal assets that are seized. And so it would take an act of Congress to do what Donald Trump has proposed doing.
And it would also be against the whole philosophy of seizing these assets to help get the victim some restitution.
Right. The whole philosophy of these funds, which are held either by the Justice Department or the Treasury Department, is to, again, make victims whole or support law enforcement. It's not considered an investment vehicle. It's not, if you will, buy and hold opportunity. And the government is not supposed to time the market either, say, oh, well, if we wait another month or two, Bitcoin's going to go up. They're supposed to try to sell it as quickly as they can, as quickly as they're legally allowed to do. Now, I would say there have been problems in the last few years in how the U.S. Marshals have handled the assets, and so they have contracted out with Coinbase to do a large portion of that. They recently awarded that contract. And so there have been some changes in how the government actually holds and sells these assets, but the principle remains the same.
I was wondering if there is a problem because of the nature of Bitcoin. Normally you'll see there's an auction. You know, the federal government auctions off these cars, et cetera, they've seized. But do they do that with Bitcoin?
They did do that with Bitcoin, but they've moved away from that process, and it's not the same auction format as it used to be. So they have professionals who work out sales with interested parties.
Is this contrary to what his position was when he was president?
When he was president, he took a very dim view of crypto and did not see it as a prized asset the way, digital advocates do. And so this is happening at the same time, obviously, as he's in a very tight presidential race and needs to raise a lot of money. And cynics would say that he's making a pitch to receive campaign contributions from the crypto industry, which has been a very generous industry and has given a lot of money to politicians in Washington to try to influence a very unsettled regulatory environment.
Crypto industry donors have poured more money into the 2024 election than in all prior cycles combined, according to Open Secrets. And Trump has discussed cryptocurrency policy with Tesla CEO Elon Musk. According to a person familiar with the talks, he's hosted crypto mining executives at his Mar-a-Lago resort and vowed to commute the sentence of Ross Ulbright, who's serving a life sentence after he was convicted of running the Silk Road marketplace, where customers used virtual currencies to buy illegal drugs and hacker tools. And significantly, Trump's campaign said in May that it would begin accepting donations in digital assets. Since then, it's raised $4 million from a mix of digital tokens. That's according to Bloomberg sources. Let's turn now to B. Riley Financial. Its shares lost more than half their value amid a new round of write-downs and a widening U.S. investigation. Tell us more about that.
On Monday, B. Riley announced that it was taking a substantial quarterly loss and that it was also cooperating in an SEC investigation. We also at Bloomberg reported earlier that there was a widespread SEC investigation of the soundness of the financial reporting by B. Riley. There have been a lot of questions about how accurate their financial reporting is, whether they're accurately reporting the underlying value of receivables that are backing a number of their assets, and that the SEC is looking at the relationship between B. Riley's founder, Bryant Riley, and another businessman, Brian Kahn, who used to be the CEO of Franchise Group, Inc., which owned a number of retail franchising companies. B. Riley helped take FRG public a few years ago, and last summer helped take them private. And there's a number of interlocking financial relationships involving loans and receivables between Brian Kahn, his company, Bryant Riley, and B. Riley.
And the SEC's civil investigation is proceeding along with a federal criminal investigation in New Jersey. What are prosecutors looking at there?
And that is into yet another firm called Prophecy Asset Management. And one of its co-founders in November pleaded guilty in a $294 million fraud. And in that case, the prosecutors said that Brian Kahn was an unindicted co-conspirator. And we reported that last November. When that happened, there were a number of questions raised about the relationship between Brian Kahn and Bryant Riley. And that relationship goes back many years and spans a number of businesses.
And what has their response been to this?
I would say that Bryant Riley says that he did nothing improper with Brian Kahn. He has no knowledge of any criminal activity, and that 2 internal investigations have essentially cleared him of any wrongdoing and his firm. Brian Kahn also said that he did nothing wrong. He hasn't been charged. Bryant Riley hasn't been charged. So it's possible nothing will come of any of this, but investors have taken a very dim view of the financial health of B. Riley.
So how long has the SEC investigation been going on?
For many months at least, and it's recently escalated is what we've reported. They're continuing to look at a number of questions about the financial disclosures, and the deeper they get into it, the more questions they have.
Are the SEC investigators and the federal prosecutors working together in any sense?
I believe that they are working on a parallel track, that they are working cooperatively with each other. I mean, there's a specific legal meaning to having a formal cooperation between the two, the Justice Department and the Securities and Exchange Commission. I don't know the precise nature of that relationship, but I do know that their attorneys and investigators have been working along the same track.
Of course, it's a developing story, and I know you'll keep us on top of it, David. Thanks so much. That's Bloomberg legal reporter David Voreacos.